statements are rooted in restorative justice, and they aim to empower victims to become involved in the criminal justice process by giving them a voice, thereby enabling them to share their experiences as well as impact statements. And by doing so, they assist a court to arrive at a more informed and appropriate sentence, which takes into account their needs as well as their concerns. It should also be noted, it's important to note that yes, we've been given a background about the rationale of these statements. They also serve to send a message to the perpetrator or an accused person about the impact of their actions. That is the impact of the crime on victims. Just to summarize, ultimately, purpose of victim impact statements is to provide a judge with a comprehensive understanding of the case, which includes the dimensions of the crime, that is the nature, the extent, and the severity of a crime, the repercussions of the crime. It's important that you also have to consider the short-term effects as well as the long-term effects of that is the impact of crime. Also to be noted are also the repercussions of the potential sentence, that is on the victim, on society, as well as the family of the victim. And then armed with this information, a judge can therefore mete out a sentence that serves the interest of justice. I just thought I bring one issue relates to criticism of victim impact statements. In some jurisdictions or some critics have stated that these may have a prejudicial effect on an accused person. So the question for food for thought is, if an accused person has the right to address the court and then plead for mercy during sentencing without compromising the objectivity of the criminal justice system, then why shouldn't a victim also have a voice? Would such a cause raise questions about objectivity? So drawing from the case, US Supreme Court case of Payne versus Tennessee, you can conclude that the victim's perspective is an integral aspect in a sentencing process, just like the involvement of the accused person, and therefore it should never be viewed as a threat to the objectivity of the criminal justice system. Moving on to international perspectives, we have closer to home the example of South Africa. The South African justice system has made significant strides in incorporating victim impact statements, which aim to promote justice in the criminal justice system. It enhances public perceptions of the justice system and also increases victim satisfaction. I'll refer to the case of S versus Gerber. In this case, the importance of victim impact statements was acknowledged. The court in this case acknowledged that it did not have the necessary expertise to draw conclusions about the effect of crimes such as indecent assault or rape on a victim, could be a child victim, but found the use of victim impact statements valuable in meting out sentence. In another case, I apologize, I'm unable to pronounce this, this the names. However, the point is that it was also acknowledged in this case that it may be extremely difficult for an individual, even a highly trained professional such as a magistrate or a judge, to fully comprehend the full range of emotions and suffering that a particular victim might go through. They could be victims of sexual violence. The point is that each and every individual comes from a different background, they have different support systems, and therefore they do not respond to trauma in the same way, and therefore there cannot be a one size fits all system or approach. Coming back to our local context, it is common ground, common knowledge that victim impact statements are not specifically provided for in the Criminal Procedure Code, specifically Section 302 of the Criminal Procedure Code, which I think to be important that we just, as a way of reminder, we state what it says. It states the court may, before passing sentence, receive such evidence that it thinks fit in order to inform itself as to the sentence proper to be passed. There are certain points that I thought would be important to highlight. Firstly, that Section 302 falls under Part 9 of the Criminal Procedure Code, which governs procedures for trial before the High Court. And drawing from this, it's clear that this section does not apply to subordinate courts. It should also be noted that Section 302 is drafted in discretionary terms or language and therefore grants a court the option to exercise discretion in its application. And an examination of Section 302 also further reveals that it does not specifically point a court to any particular issue for consideration when it comes to sentence. I'll refer to the case of Eddie Mwanza, Bow Wow versus the People, which is a court of appeal decision. The Court of Appeal in this case referred to the Supreme Court's decision of Darius Chandankole and two others versus the People, which specifically addressed, among other things, Section 302 of the CPC. It should be noted that the Supreme Court in this case, commenting on Section 302, noted that in other jurisdictions, after conviction and before passing sentence, courts often conduct a sentencing hearing where they receive evidence from the prosecution and the defense. And this evidence encompasses evidence of the seriousness of the offense, previous convictions, if any, relevant reports, evidence from the victim's family, mitigation, among others. Drawing from the Supreme Court settlements, it's very clear that it considered international standards and the incorporation of best practices into the sentencing hearing process in this jurisdiction. Notwithstanding that Section 302 has been framed in general terms, the Supreme Court's sentiments provide clarity on how the section should be interpreted and applied in the context of sentencing hearings. Furthermore, drawing from the Supreme Court sentiments, the broad interpretation of Section 302, in my view, can be extended to include victim impact statements as a form of evidence which will provide valuable insight into the impact of crime on the victim's life and also inform the sentencing decision. How has Section 302 been applied in this jurisdiction? We have one case example. I'm sure by now we all know, we are aware of this case, the People versus Mulenga and Siakonga. In this case, the High Court, as we all know, we've read the judgment, exercises discretion under Section 302 to consider the impact statements before imposing sentence. The reading of the judgment reveals that the High Court received expert reports that detailed the impact of the offenses on the victims' educational, social, and psychological well-being. Further, the court took into account the impact of the offenses on the victims and also determined that an appropriate sentence would be the one under the circumstances that would be adequate and proportionate to the nature as well as the gravity of the crime, and also considered the manner in which the crimes were committed. For the purposes of this conference, how can prosecutors apply Section 302 in order to ensure that justice is served? It is recommended that rather than just aimed at stating that there are no previous convictions at the sentences or before sentence, as it usually happens, prosecutors should note that that is what I had earlier stated in the presentation, that a judge may not always have the expertise to fully comprehend the impact of crime on victims. I may just cite One example, if it's before the High Court, you have these attempted murder cases. We've had those cases where a victim may have lost an arm or a leg. So when the judge imposes a sentence, probably what will be in the mind of the judge will just be principles of sentencing and also that, okay, this victim may have lost a limb. But behind those considerations, a judge may not be aware that this particular victim was a farmer, the victim was a driver, and the effect of the crime will therefore be long term. So, how will this person survive? It should also be noted that it's also crucial that in cases where there have been pleas of guilty, that Section 302 is invoked, as it was done in the Mulenga Siakonga case. And in cases where there are pleas of guilty, it should be noted that the judge in such cases will not have the benefit of hearing evidence. And that's why it's important that the prosecutor who has full information about what could have happened to this victim invoke Section 302 so that an appropriate sentence is meted out. And even in cases that go to the full trial process, victims are usually just viewed as witnesses who are called by the prosecution to prove the elements of a crime. As stated earlier, under such circumstances, the judge may not comprehend the impact of the crime on the victim. And I think I've already given examples of those attempted murder cases where someone will survive, but however, there will be long term effects when it comes to the issue of financial impact. There's also another tip that is prior preparation and adequate preparation. And on these points, I'll refer you to the case of Luisha versus Regina. Due to time, I'll not go through the facts or the main principle. I'll just refer to the main principle. So this decision was premised on Section 298 of the Nyasaland Criminal Procedure Code. As you can see, this section was couched in exact terms as Section 302 of the CPC. So the main point to be listed from this decision is that the case highlights that in considering that that is in sentencing hearings, it should be noted all the time that the procedure to be followed is the ordinary procedure in a criminal trial. And it is thus important that we prepare adequately as we anticipate to invoke Section 302. It's thus important that sufficient evidence is gathered earlier on, as it is done in other jurisdictions. It should be something that should be done a day before, that should be done in some jurisdictions. Preparation takes place just from the very, very beginning once a victim or witnesses have been interviewed. Prosecutors should also anticipate potential objections from the defense as they invoke Section 302. And that's why I'll emphasize that key preparation is adequate and very critical. So the next point, I'll refer to one criticism of victim impact statements, which is that they often overlook the potential invasion of a victim's privacy, as the result might be that sensitive information, personal information about the victim may be revealed to the public. And this is especially true for victims of gender-based violence and victims of sexually motivated crime, as well as domestic abuse. So in response to this criticism, it's been recommended that a tailored approach be adopted where victims should be fully informed from the very beginning about the implications of giving impact statements. And this will include informing the victims about the ramifications of making impact statements, and then leaving it to them to decide whether to give a statement or not, or maybe have one presented by other professionals. With this approach, it, this approach just highlights again the need for proper preparation as well as support for victims. The point that I made that preparation should not be done a day before, 2 days before, but should be done within reasonable time to give these witnesses an opportunity to fully comprehend the impact of giving these impact statements in court. I'd mentioned, highlighted earlier that Section 302 does not apply to subordinate courts. So, how do prosecutors go around this? In my view, this is just a suggestion. It will be important that since you cannot invoke Section 302 in the subordinate courts, why not ensure that you leave evidence on impact during the trial? And this could involve the calling of expert witnesses. In conclusion, as the presentation has demonstrated, victim impact statements are important. They have a positive impact in sentencing. And as the examples from other jurisdictions have demonstrated, they're worth emulating. And in terms of Section 302, the use of victim impact statements is a form of evidence that fits within the broad scope of the section and not only promotes justice, but also ensures that the voices of the victims are heard and considered in court. I think I'll end here. Yeah, thank you all for listening.
Thank you so much, Judge. That was Judge T.S. Musonda, a judge in the High Court in the Children's Division of the High Court. At this moment, we'll call Ms. Lynn Kalin. She is an assistant director in the Public Prosecution Service of Northern Ireland. She will give us her perspective. Thank you.
Thank you very much, Cynthia. Good afternoon, ladies and gentlemen. I stand on the protocols already observed and thank you very much for the invitation to address you this afternoon. As Cynthia has outlined, I'm an assistant director in the Public Prosecution Service in Northern Ireland, and I have been invited to speak to you this afternoon about how victim impact statements are used in the jurisdiction which I practice in Northern Ireland to promote justice in criminal cases. To start, I'm going to look at the genesis of victim impact statements in Northern Ireland and really their basis in law in our jurisdiction, and then examine how these statements are now routinely used as part of the sentencing hearing in all criminal cases in our jurisdiction. So to start, I'm just going to look at the Northern Ireland Victims Charter, which really provides the context for the introduction of victim personal statements in our jurisdiction. So victim personal statements have been in operation in England and Wales, in other parts of the United Kingdom since 2001, but really have only come into use in Northern Ireland from approximately 2013. The opportunity then to provide a victim impact statement became a statutory entitlement for all victims following the enactment of our Victims Charter on Friday the 13th of November 2015. So a relatively recent development in those terms. This charter outlines how victims of crime should be treated and has statutory effect in our jurisdiction. Compliance with the charter is monitored by a victims commissioner, and the rights enshrined in the charter are replicated in our code for prosecutors and also in our policies which deal with how we handle victims and witnesses in criminal cases. Also within the Public Prosecution Service, we have a victims champion who oversees compliance with these policies. You'll see on the screen that there is a link to the charter which is available to be read in full for anybody who has interest. The charter is for victims of crime, including those who have suffered physical, mental, emotional harm or economic loss caused directly by the crime. The Charter makes it clear to victims and service providers alike the range and standard of services that a victim of criminal conduct is entitled to receive as they progress through the criminal justice system. The Charter, in its entirety, sets out all of the obligations on service providers, including PPS, and this includes time limits which must be adhered to and clarifies victim entitlements throughout the process. It sets out that victims of crime are entitled to be recognised and treated in a courteous, dignified, respectful, sensitive, tailored, professional, and non discriminatory way. One of the many entitlements which a victim of crime has under this Charter is the entitlement to have the opportunity to tell the court, in their own words, how the crime has affected or continues to affect them physically, emotionally, financially, or in any other way. This entitlement is given effect through the provision of these victim personal statements. Their purpose is to allow victims a more structured opportunity to explain how they have been affected by the crime or crimes of which they were victims. They provide a practical way of ensuring that the sentencing court will consider any harm which the offence caused, reflecting on the evidence of the victim themselves about the specific and personal impact of the offence or offences, or in the cases of homicide, on the family of the deceased. You'll see this entitlement is set out in Section 3 of the Charter at Entitlement 3.1. This entitlement provides that a victim is entitled to be given the opportunity to make a written personal statement once a decision to prosecute has been taken, based on the test for prosecution and where it is practicable to do so. This entitlement applies if the person is a direct victim of the crime, parent of a child victim, a close family member or a representative of a deceased victim, or a representative of a person who is unable to make a statement due to their physical or mental state. There is a body of case law in England and Wales which deals really effectively with the use of victim personal statements in criminal proceedings right across the United Kingdom, and this has binding authority also on our jurisdiction in Northern Ireland. The leading authority on the use of victim personal statements as part of the sentencing exercise is that the case of R versus Perkins, Bennett and others. This is an English Court of Appeal case in which the court held that such statements are evidence and should therefore be in proper form. This means that they must be recorded as a formal witness statement. The judgment also emphasised some very important points that need to be taken into consideration in the recording and making of these statements. It highlighted that it is for the complainants themselves personally to decide whether they wish or not to make the statement, that the complainant's opinion about the type and level of sentence must not be included within the body of that statement, that the victim personal statement is evidence and should be treated as such and served in a timely manner by the prosecution. Moreover, that responsibility for presenting all admissible evidence, including a victim impact statement, remains with the prosecution. As was highlighted by my learned friend, similar to you in your own jurisdiction, this statement can be challenged in cross-examination and may give rise to disclosure obligations. For example, if it contains information which contradicts other parts of the prosecution evidence or in some other way undermines the prosecution case. And in certain exceptional cases, it may even be used after conviction for the purposes of appeal to question a complainant's credibility if an issue arises. So just to talk in practical terms then about how the victim personal statements, just go back, is that okay? Yeah, sorry. Operate in our jurisdiction. In practical terms, how this actually is given effect to is that there is a scheme and the entitlement to the scheme is notified to the victim along with the decision to prosecute letter. They receive an accompanying leaflet which directs them to the service provider who will be responsible for the recording of the statement in that evidential form that we've discussed. It's really important to note that this is not the responsibility of the prosecutor in our jurisdiction. This is done by either police or victim support services. While the victim personal statement can be recorded by those services at any stage of the criminal justice process, it must not be served until after conviction, as it is relevant only to sentencing, not to determining guilt or innocence. There are, as we've said, very strict requirements about the information that has to be provided to the victim before they make this statement, including a warning regarding the consequences of making a false statement. To give effect to this, there is a declaration at the top of the statement which is recorded in our jurisdiction, which must be completed to the victim, and they must be told of the consequences if they do not comply with that declaration. The statement must not include the views of the victim on the defendant, on any of the alleged offences or offences which were not before the court, or indeed on any potential punishment. This is because these views are not admissible in court. In the case of Nunn, again, an English Court of Appeal authority, they explained the rationale for this. The court held, if the victim feels utterly merciful towards the criminal, and some do, the crime has still been committed and must be punished as it deserves. If the victim is obsessed with vengeance, which can in reality only be assuaged by a very long sentence, as also happens, punishment cannot be made longer by the court than would otherwise be appropriate. Otherwise, cases with identical features would be dealt with in widely differing ways, leading to improper and unfair disparity. If carried to its logical conclusion, the process would end up by imposing unfair pressures on the victims of crime to play a part in the sentencing process, which many of them would find painful and distasteful. This is very far removed from the court being kept properly informed of the anguish and suffering inflicted on the victims by the crime, which is the purpose of these statements. So if the statement contains inadmissible matters such as we've outlined there, it must be redacted by the prosecutor before it is served on the defence and the court. These victim personal statements in our jurisdiction will very often be referred to in whole or in part and read aloud in open court by the prosecuting advocate as part of the sentencing hearing. The statement will form a very important part of the papers placed before the sentencing judge, and the judge will always have read these in advance of the sentencing hearing. Sometimes they may also choose not only to indicate that they have taken the contents of these statements into account, but to quote relevant passages in court as part of their sentencing remarks. Of course, the selection of any passages for quotation or indeed summary, it falls to the advocate and indeed the judge to be very sensitive to the position of the victim, and on some occasions, where required, in more sensitive cases, to respect the victim's privacy. It is important to note that the contents of the victim personal statement and the weight attributed to them will often form a very significant part of the considerations of our Northern Ireland Court of Appeal in criminal appeals brought by the defendant against sentence, and also in prosecution appeals against unduly lenient sentences. A recent example of this can be found in the case of William Hutchinson. This was a murder case in which Mr. Hutchinson, very belatedly on the morning of his trial, pleaded guilty to the murder of his partner, Alice Morrow, with whom he'd been in an intimate relationship for 11 years. Post-mortem examination established that her death had resulted from a sustained blunt force assault, including 71 single or groups of injury, including extensive bruising to her body and rib fractures which would have impaired her breathing. There were also, very notably, finger marks and bruising to her jaw and throat, supporting a conclusion of attempted strangulation or asphyxiation. Following his very late guilty plea, the defendant was sentenced to a life imprisonment with a minimum tariff of 21 years before consideration for release on licence. The defendant sought to appeal against the sentence imposed on the basis that it was manifestly excessive. And in dismissing the appeal, the Lady Chief Justice of Northern Ireland gave a ruling in which she expressly noted that this was a significant femicide case involving a very high level of domestic violence, and she took the opportunity to provide guidance to sentencers in dealing with such cases. The court endorsed the position taken by the sentencing judge following trial that the murder was the culmination of cruel and violent behaviour by the offender over a period of time, and noted that this was a significant aggravating feature in this case. The court made it clear that behaviour of this kind towards the deceased and his previous female partners could be taken into account to establish a culmination of cruel and violent behaviour over a sustained period of time. The court found no merit in any of the grounds of appeal. The judge's sentence was held to be neither wrong in principle nor manifestly excessive, but rather to reflect the serious nature of the offence, characterised by significant violence against a vulnerable woman in a domestic setting by a man with a prolonged history of significant violence. Court recognised society's utter condemnation of such behaviour and held that this should be a signal that offending of this nature will, in each of these cases, attract commensurate sentences. The significance of the victim impact statements provided by the family of the deceased in this sentencing exercise was specifically noted by Our Lady Chief Justice at paragraph 53, where she stated, "We are aware of the effect upon the family of Alice Morrow of this horrific offence. We have been greatly impressed by the victim impact statements which we have read. We echo the comments of His Honour Judge Miller, who in his sentencing remarks said this: there can be no doubt that Alice Morrow's life was ended brutally and most cruelly by the defendant in what was clearly a sustained attack during which she must have suffered most grievously. No words from this court can lessen the pain, hurt, and sense of loss felt by her family." The Lady Chief Justice concluded in her own judgment that hopefully with the conclusion of this appeal, the family may be allowed to properly begin the grieving process and indeed the journey towards rebuilding their lives. This judgment very clearly demonstrates the significant impact that a properly prepared victim personal statement can have as part of a properly conducted sentencing exercise. And there are a number of similar available authorities on this point, which would be available to be shared with the presentation for anyone that has an interest. It would be fair to say that it is a settled principle of sentencing in our jurisdiction that victim impact statements will form an important part of the considerations for the sentencing judge and appeal court in every case. So just to move on, there is a distinction to be drawn between the victim personal statements, which I have discussed, which do detail the victim or the victim's family's own account of the impact of the crime on them and are used to assist the judge as part of the sentencing exercise. These are to be contrasted with a court-ordered victim impact report. In most cases, the victim will be able to adequately represent the suffering that they have sustained as a result of the commission of the offence through a victim personal statement. But there may be some exceptional cases where a victim impact report is sought and ordered from the court. These are cases where the level of suffering of the injured party appears to be considerable, and it is thought that a diagnosis of a recognised medical or psychiatric condition seems probable. And sometimes these victim impact reports will accompany and complement a victim personal statement. The victim impact reports are prepared by an expert, such as a psychologist or a psychiatrist, and they are required to provide their specialist opinion on the impact that the crime has had or continues to have on the victim and any consequent needs of the victim. Again, importantly, the report must not include any comment about the offender or a potential sentence for the crime. These victim impact reports can be of considerable assistance to a judge also when assessing the correct sentence, particularly if the victim has suffered significantly in an emotional or psychological way and continues to be affected by the crime. In such cases, the victim is likely to have received counselling and will usually have received a recognised medical or psychiatric diagnosis. Experts who are requested to prepare these victim impact reports will have access to the relevant independent evidence and information to allow them to ensure that the report which is provided to the court is proper, accurate, and it's a reliable assessment of the impact on the victim. Where this is not done, this can very significantly reduce the weight that can be attached to a report that has been prepared without recourse to crucially relevant and readily available records. This issue was examined by our own Court of Appeal in the case of Kubich, which was again an appeal against conviction and sentence, this time for an offence of rape. In allowing the appeal against sentence and reducing the period of imprisonment to 7 years, the then Lord Chief Justice Sir Declan Morgan, delivering the judgment of the court, reinforced the position that a victim impact report, uncorroborated by medical evidence, cannot be relied on to demonstrate an especially serious physical or mental effect on the victim as a specific aggravating feature for sentencing purposes. He noted that if a finding of harm is to lead to an increased sentence of imprisonment, it must be convincingly established. properly prepared and evidence-based report from an independent expert can, however, be a very powerful way to ensure that the level of harm caused to the victim is properly reflected in the sentence imposed on the defendant. This is particularly the case and particularly relevant in cases involving serious sexual offending or domestic abuse cases where the impact of the abuse and the offending behaviour has had a significant impact and causes ongoing harm to the victim. This is properly reflected in the imposition of an enhanced sentence to reflect this increased level of culpability and harm. This is a fundamental principle of the sentencing exercise in our jurisdiction, and it is incumbent on the prosecutor to ensure that all relevant evidence is placed before the sentencing court to ensure that the sentence which is imposed is based on an objective assessment of all relevant factors. So, in conclusion, if prepared correctly and properly presented to the court at the time of sentencing, both a victim personal statement and a victim impact report, if appropriate, can have a very significant impact on the outcome. These ensure that the harm caused to the victim and or their family by the perpetrator are properly recognised and reflected in the penalty imposed by the court. I hope that this presentation has been of interest to you this afternoon and provides an insight as to how this issue is dealt with in our jurisdiction. I thank you.
Thank you so much, Judge and Lynn, for those insightful presentations. At this time, we'll allow for 2 questions. Yes, we'll start with you, ma'am. Kindly introduce yourself and mention to whom the question is addressed to.
My name is Diana Chilambwe. I'm coming from Wildlife Crime Prevention. And my question is addressed to Judge Msonda. My lady, I would like to know how receptive the bench would be to a victim impact statement being produced in environmental crime, and if there would be a difference that would be noted in how it receives it as compared to crimes that are committed against a person. What can be done to change the narrative?
Thank you for that question. We'll allow for another question. The answers will be given at the end. Mr. Milambo, I saw your hand.
Thank you. Good afternoon. My name is Milambo Sinyangwe from National Prosecution Authority. And I guess any of the 2 panelists can answer the question. I just wanted to find out if an argument can be made for those vicariously affected by the crime can give an impact statement, and if yes, to what extent? Can an indignant bystander, for example, be allowed to give a statement against a convicted person awaiting his sentence? Thank you.
So you may repeat your questions and kindly be loud. The speakers didn't get your question.
Okay, thank you. So the topic is on victim impact statements. My question was if an argument can be made for those vicariously affected by the crime to give such a statement, and if yes, to what extent? Can an indignant bystander be allowed to give a statement against a convicted person awaiting his sentence?
That question was directed to who?
Either of the 2 panelists.
Noted. Judge, you may take the first question.
So just to answer the second question that was asked there first, I I can address that in part, in that I suppose it would be difficult to determine how this such a statement would be received in this jurisdiction. But I can provide context as to how a statement recorded in these circumstances would be accepted in our jurisdiction. Certainly, yes, particularly where we would see this as being particularly relevant is that in cases of domestic violence, sometimes you would have children who are affected. They're maybe not actually physically assaulted during the attack on their mother, but they may witness it, and therefore it has an impact on them, a profound impact on them. So yes, in our jurisdiction, it is possible for victim impact statements to be recorded from those who are vicariously affected by the trauma of the offence being committed. But the circumstances in which they will be admitted will really depend on the relevance that they have to the crime which has been committed. But certainly, there are circumstances where they can be admitted. Similarly, in homicide cases, such as the one that I referred to in my presentation, it can be particularly powerful and relevant to the court as part of the sentencing exercise to have statements that are prepared by family members of the deceased to show the impact on the wider family network as a result of the homicide. Not just children, but the wider family network, siblings, parents, and things as well. So it is possible, and they can have a direct impact, but really it does depend on their relevance and proximity to the offence and the impact that it has caused. I hope that answers your question.
So in addressing the first question, as I stated or noted in the presentation, Section 302 is out in a very broad terms. And in my view, it specifically states that to allow a judge to receive whatever evidence will be deemed appropriate. So irrespective, okay, of course, in subordinate court, it may be a different case since Section 302 does not apply. But if it did apply, I believe that in the context of environmental crime, victim impact statements would be would be received, and especially that such crimes have long-term effects, could be on the ecosystem, society as a whole. I wouldn't see why a court would decline to receive such evidence if it will be necessary for it to come up with a sentence that will really reflect the interest of justice. And as I stated, when it comes to the subordinate courts, from my view, prosecutors will be maybe at liberty to even lead evidence, unless probably in those cases where pleas of guilty, but where a matter goes to trial, it will be important that you lead evidence that will assist a court to come up with a just decision or just sentence.
I hope those were the only burning questions. If we have other burning questions, we'll have to get in touch with our presenters because we do not have much time at this moment. Would like just to state that as prosecutors, it is time for us to I'm being informed that there's one burning, very burning question. We'll allow it. Thank you.
Thank you. I had considered my question not such a burning one, but I will take the opportunity. I am More Blessing. I'm from Zimbabwe. We have recently introduced the victim impact statements. And what I have noticed is that we sort of have pro forma or a statement which has set questions that a victim has to answer. So it sort of restricts the victim on the impact of the offense on them, I would want you to comment, since I think you've had victim impact as part of the system for a longer time, whether this works. Secondly, I heard that the victim does not sort of suggest a sentence. In our jurisdiction, victims actually suggest sentences. So, for instance, because of the emotions attached to offenses, you find that even for a theft matter, someone may say, lock them up for the longest of time, which obviously doesn't make legal sense. But I'm thinking from the perspective of why we have victim impact statements. So, in the case of Payne versus Tennessee, we are saying the victim's voice should be heard in as much as the defendant. So I'm also thinking, if an accused can pray for, say, a community service or a certain sentence, why should the victim not do the same? I think that is all.
So, in respect of the first question, about the pro forma, about the impact of the offence on the person, what we do is we provide guidance and assistance to the victim by way of a leaflet that explains what a victim personal statement is, what its purpose is, and the kind of information that it should include. It's not restricted to a pro forma, and that does work for us in our jurisdiction. I would, I would have a concern that maybe a pro forma would, as you say, limit maybe what a victim would actually address in their victim personal statement, particularly if they have a pro forma to complete, that it doesn't allow the narrative to flow properly and effectively. And I mean, certainly my own experience would be that in our jurisdiction, some of the victim impact statements that we would receive, particularly in our more serious cases, can be extraordinarily impactful and really describe, a course of conduct over a number of years that has had a totally devastating impact on their life. And it's right and proper that that's properly reflected before the court and taken into account as part of the sentencing exercise. I think you would struggle to do that on a pro forma approach. But what I would say is that, perhaps it could be looked at from a position, something similar to what we have adopted, where there are suggestions given as to what it might include, rather than being prescriptive as to what should be said and how it should be said, to allow the victim to have that narrative. And then in response to your second question, about the equality of arms, essentially, to allow the victim also to have a say on the sentence that should be imposed. Again, while the victim won't the victim won't be in a position to do so, because our jurisprudence is quite well settled, and I'd referred in my presentation to the case of Nunn as to the rationale for why this is actually the case, that the victim must not be allowed to actually refer to the type of sentence that should be imposed, because sentencing is a matter entirely for the judiciary, and it would fetter the discretion of the judge in sentencing if the victim were really allowed to have that say and to effectively dictate what the sentence should look like in the case. However, it's important to draw out in the victim impact statement and it can be done, the effect that any sentence may have on this. And for example, I would see sometimes in victim impact statements in homicide cases from family members of the deceased, where they will not comment on the sentence. It's a mandatory life sentence, so there is a level of certainty around that. But in our jurisdiction, then what will happen is that there's a tariff set, as was in the case of Hutchison, for the time that the defendant will spend in prison before they're considered for licence. And the victim, the family of the deceased, can't have a direct say on how long that tariff should actually be. what they can do and what I've seen done, and it can be quite impactful, is by stressing the severity and the impact of the loss of their loved one that will go on for a number of years. They will never get over this, that this will have a truly devastating on their life going forward for the rest of their days. That when the offender comes to be released, as he inevitably will at some stage later, that they perceive that this will further increase their trauma and harm, because he'll be free to live the rest of his life where they live with effectively the life sentence of the loss of their loved one. And that in itself can be so powerful and so impactful, and give that voice to the victim, but not directly commenting and seeking to directly influence the decision of the judge as to sentence, which is entirely a matter for them. So we can reflect the position, but not dictate the position, if that answers your question.
Thank you so much. Really been a very interesting topic. It's really been a very interesting topic at this moment. Allow me to release my speakers as we give them a round of applause. Thank you. I'll hand over to the Master of Ceremony, Mr. Bako. Thank you so much.
Thank you very much. Another applause for the participants, for the panelists. Well, we continue with our program for today. As you may have noted, we did adjust the program a bit. We have one session that we should have had from 11:50 to 13 hours. If you look at your program, that's the session that we are going to go into right away. So this is the session that is dealing with combating environmental crime, smuggling, and wildlife crime. So I will call to the podium the moderator, Mr. Hastings Sichoni. And after this session, Undi Kumbukire should be ready to come and do the presentation. Abzam.
Thank you very much, Mr. Bakpo. All protocols observed. To the distinguished invited guests, ladies and gentlemen. On a lighter note, I'm pleased to see Judge Msonda in our midst, because 9 years ago, when I first presented my case before court, which was a defilement matter, it was before her court when she was the principal resident magistrate in Eastern Province. Diving into our topic of discussion today, environmental crime, smuggling, and wildlife crimes pose a significant threat to the health of our planet and its inhabitants. These illicit activities have devastating impacts on the environment, human well-being, and the economy at large. The crimes often overlap and are interconnected, requiring a comprehensive and coordinated approach to prevention, investigation, and prosecution. In that regard, it is essential to address these dangers through robust laws, enforcement, and international cooperation to protect the environment, human health, and sustainable development. I'm privileged this afternoon to be moderating the presentations from two distinguished speakers who will be presenting on the topic enforcing the law, a frontline approach to combat environmental crime, smuggling, and wildlife crime. Ladies and gentlemen, may we welcome to the podium the speakers. To start with, Ms. Diana Chilambwe, the Justice Manager, Wildlife Crime Prevention. A round of applause, please. Also, our second speaker, Mrs. Gracilia Mlenga, who is the Deputy Chief State Advocate for Taxation and Financial Crimes Unit at National Prosecution Authority. A round of applause, ladies and gentlemen. Thank you very much. If you look closely at the programs that you have, the program leaflets, You will notice that we were supposed to have three distinguished speakers. Unfortunately, with regards to one of them, his schedule collided with another meeting that he was scheduled to have in another jurisdiction. Hence, we only have two who have, however, adequately traversed through his presentation to ensure that everything that the other speaker had prepared is brought to us this afternoon. Without any further ado, I'll go ahead to introduce the first speaker, Ms. Diana Chilambwe, the Justice Programs Manager. And just briefly, with regards to the first speaker, she's an advocate of the Superior Courts of Zambia with 6 years dedicated experience in wildlife conservation and ecosystem protection. With a commitment to modern legal practices and innovative problem solving, Ms. Diana Chilambwe has honed her ability to stay abreast of legislative development and interpret new policies within the conservation sector. At Wildlife Crime Prevention Zambia, Ms. Chilambwe heads a team of lawyers who are pivotal figures in collaborating with the Department of National Parks and Wildlife, the Forestry Department, the National Prosecution Authority, the judiciary, and other law enforcement agencies. Without any further ado, may we welcome to the podium Ms. Chilambwe.
Good afternoon, ladies and gentlemen, and I will write on the protocols already observed. So this afternoon, as we discuss enforcing the law, frontline approach to combat illegal wildlife trade. As you can see from my background, you may have an idea by now what we're going to talk about. We are going to discuss the aspect of environmental crime that relates to illegal timber trade. And the beauty about speaking on the second day, towards the end of the day, I am now going to ride on the shoulders of giants that have gone before us and have laid really good foundations on especially financial investigations. Okay, so to begin with, Zambia's forest area is estimated at 44.8 million hectares, and this is something that has been taken note of by the Food and Agricultural Organization of the United Nations. And part of this, we have 300 local forests, and then we also have 180 national parks. So those also form part of the forest coverage that we have. And then we have 36 game management areas. And so all this represents about 60% of the country's of the country's landscape. And then if we look at the rate of deforestation, I I would understand a number of us coming from especially Mchinga province, the southern province, northwestern province would attest to the number of bags of charcoal that they find along the roads, or the trucks that are laden with timber, or the amount of vast land that has been cleared out due to cutting down of trees. And so would attest to the rate at which we have been affected by deforestation at the moment. And of course, for those who've come in Lusaka, I don't know what it is like in your provinces, but our load shedding schedule, we don't exactly have a schedule because of the water levels that have gone down, the climate change that we are experiencing right now. So all these are some of the impacts of um, deforestation. So what is the importance of conserving forests? First of all, forests are a reservoir of the biodiversity habitats. So one would ask, why would we be interested to talk about, maybe most times we would hear wildlife crime prevention or Department of National Parks and most partners talking about wildlife. Why are we suddenly interested in talking about conservation of forests? we cannot have wildlife without a habitat. Or is that even possible? So forests provide not only a home to wildlife, not only a source of non-wood products for people living around these forests. We have people that rely on beekeeping as part of their livelihood. We have a sustainable way of using forests for fuel production. And then we also have trees that are found along catchment areas of water bodies. So the forestry department will tell you that the harvesting of timber is not allowed around or near any water bodies. But these are the problems that we are seeing now, where trees are being harvested around water catchment areas. And then to delve into the illegal timber trade. Zambia has always been identified as a source and transit country for illegal wildlife products. And now it is at even a higher risk of illegal timber trade, being a source country to other markets outside, especially into Asia. So what are the issues that we are seeing in this illegal timber trade? So first of all, we have the law that governs forestry. We have the Forest Act, Chapter 4 of 2015, which regulates the exploitation of forests. So it regulates how permits are issued, how licenses are issued, how they should be used, and also just gives power to the forestry department to be able to maintain the sustainable use of forests. And then we also have the forest exports of timber regulations 2015. This restricts the timber export. So this restricts the timber export to sawn timber, finished timber, and trees that are coming from plantations. And so one would ask, why then do we see trucks laden with logs of timber heading towards Chirundu, going all the way and attempting to cross the border? Because those are not part of the products that should legally be exported. So that is part of, and in addition to that, we have seen how the species that have been targeted by the illegal timber trade. There's the African blackwood, then there's the Zambezi teak, there's the usual Mopani that we have a number of seizures that law enforcement agencies and the cases that NPA is dealing with currently. Most of those trees are Mopani. So the seizures involve logs, planks, charcoal, and mainly logs because they are more visible, and the planks, it's quite difficult for transporters to conceal them unless they have packed them in a container, in a truck, in a container. But even then, for an investigator who's quite alert, they are able to see some particles on that truck or